So good afternoon, everyone. Thank you for joining us today. We're excited to have you here for our webinar on estate planning basics. So your legacy is more than the wealth that you leave behind. It's all about ensuring that your wishes are honored and your loved ones are protected. Today's session will guide you through the essential steps to safeguard your financial future, focusing on key concepts like wills, trusts, and tax strategies. It's my pleasure to introduce today's speaker, Veronica Van Nest. Veronica has over 25 years of experience in estate planning, trust administration, and wealth management. Veronica is a trusted expert in this field, and she serves as Vice President and Trust Officer at Exeter Trust Company, where she oversees trust administration and investment strategies as a member of the Trust and Investment Committee. Veronica also works as a senior wealth management consultant with Manning and Napier's Advisory Services Group, collaborating with clients to evaluate and refine their estate plans. So we are incredibly fortunate to have her here today to share her expertise. Also joining us is Tim O'Leary. Tim is a vice president and advisor consultant with Manning and Napier. And Tim brings over 27 years of experience in the financial services industry. My colleague Larry Birch is with me today. And before we dive in, we'd like to remind you that we'll have questions and answers after the presentation. Please feel free to email either one of us or submit your questions through the webinar. There's a spot, I believe, on the bottom where you can ask questions, and we'll do our best to address as many of these as possible once Veronica has done the presentation. We're expecting the presentation to be about 30 minutes, 35 minutes or so. And now we're excited to turn it over to Veronica to begin our discussion on estate planning basics. Veronica, welcome. Thank you for being here.
Thank you. So I'm going to get started by talking through, just our agenda, which we're going to, you can see here on the screen. We're going to talk about the basics of estate planning. We're going to go into some tax considerations, also talk about different stages in life. What is appropriate for somebody who's, just starting their career versus somebody that has grandchildren. There's different planning that needs to go into those different timeframes in your life. So we'll talk through those, and then we'll have some questions at the end. So I often get this question: do I really need an estate plan? Everybody does. In my mind, I'm an estate planning attorney, so that's kind of that's what I tell everyone. But if you have any wealth, even the 18-year-old that might have an account, that a bank account, or might have started a Roth IRA. They might have the 21-year-old who might have an UTMA account that's becoming becoming an asset of theirs when they reach that age. They all need some type of plan. Now, whether the flip side of this is if you don't have a plan, your state is going to decide how your assets are distributed. So, which may be not ideally how people want things to be distributed. For example, I'm a New York attorney. We have in New York, if you don't have an estate plan, your assets will be distributed to, only part will go to your spouse and the rest are going to go to your kids. You might not want that. So it's very important to have an estate plan, and we'll talk through on the next couple slides what that plan should consist of for everybody. And you just want to make things clear. I've had way too many circumstances where clients have not made their intentions clear, and that just kind of leads to a mess at the end. So we'll talk through a couple of different items that you need for your estate plan. So while you're alive, the most crucial document, I believe, that an individual should have is their durable powers of attorney. So those powers of attorney are a document where you name an individual to handle your finances if you can't do that yourself. If you're, a coma, an illness, something's happening where somebody needs to assist you with your finances. There's a couple different flavors of powers of attorney. We have a durable power of attorney, which says the moment you sign it, it's effective. That is what most people have. It can be scary to some people because the those powers of attorney are effective once signed. So your power of attorney could go to the bank and clear out your bank accounts. So, I always talk to clients about making sure you trust people that are in those roles and they understand what your intentions are. And, a lot of people have some concern about that. So some clients do what we call a springing power of attorney, where that power of attorney only goes into effect at a certain event happening. Generally, that's a finding of incapacity. I'm not a huge fan of those powers of attorney. They make it a little difficult to administer because someone cannot act on that power of attorney until they go to your doctor or whatever the power of attorney says is the triggering event for incapacity. Generally, it's that there has to be a doctor's note indicating that you're incapacitated. So they would have to go to the doctor, get the note, provide that to wherever you have accounts in order for the agent to act. So there's two different flavors. I prefer the durable. People sometimes feel uncomfortable with it, so do go the springing power of attorney route. Neither are incorrect. It's just a matter of a few extra steps with the springing power of attorney. A couple important things I look at powers of attorney, and if you have older ones, sometimes they don't have all these powers. I look at, do they have the power for the agent to manage your retirement accounts? Can they name beneficiaries? Can they do gifting? So there's certain things that unless they're set out in the power of attorney, the individual you want to handle your finances can't do for you. So you want to make sure that it's set out as to what you want them to do. The other document that we use to manage assets while somebody's alive are revocable trusts. So revocable trusts kind of go hand in hand with a will, and they serve the purpose of a will. So revocable trusts it's a separate trust agreement where you have assets that are titled in the name of that revocable trust. The only thing you can't really title in the name of the revocable trust are retirement accounts. So you can title your house, you can title your bank accounts, your investment accounts. All of those assets can be titled into the name of your revocable trust. And what that allows is for any assets that are titled in the name of that revocable trust, that can, those assets will bypass probate when you pass away. So it's extremely important. I can't tell you how many times I've either drafted documents when I was in private practice or seen documents drafted here at Manning and Napier where a revocable trust was prepared for a client, but they didn't put any assets in the trust. That serves no purpose. It doesn't avoid probate, which a revocable trust will do, because there's no assets titled in the name of the trust. So it's extremely important that that next step be taken. I often get the question, well, are they more expensive than wills? They generally are a little bit more expensive than wills, but you're kind of paying at the front end versus the back end. So with wills, attorneys make their money on the estate administration, generally preparing wills and wills, powers of attorney, healthcare proxies for clients are not a big money getter for an attorney. They really make the money on the probate of the estate, where assets have to be transferred and probate proceedings have to be commenced and all that. The revocable trust, an attorney generally makes more money on the front end because there's not much to do on the back end. So they're able to, on the front end, they will create the document. They will also help with transferring assets into the trust name. They'll advise you on that. It usually costs a little more for that. So why would you choose a revocable trust over a will? A revocable trust is good if you have not the standard family situation. You might be unmarried. you don't have children, you might have just other family members that are beneficiaries, you want to leave out a family member. A revocable trust does not go through probate like a will does. So um, there's certain consents of beneficiaries that have to be done when a will is probated. That's not the same case in a revocable trust. Another reason I tell clients to create revocable trusts is if they have property in multiple states. So if you own a house in New York City, you have a house at the shore, you would then have, two different states where you would have to probate your estate when you passed away if you had a will. But if you have those properties owned by the revocable trust, there's no probate that needs to be done at the tail end. So I do think that it makes sense in a lot of circumstances. It's also privacy. Revocable trusts are not filed with the court, where wills are filed with the local, whoever handles the probate of matters in your state, and anybody can go check out those records. So they're good for that reason. A couple other, a couple other elements of estate planning, obviously the last will and testament. So that's your will where you name an executor. In naming an executor, you want to have somebody who can handle those duties. They're going to be responsible for gathering assets, making sure your final income tax return is filed, making sure all your debts are paid, handling the sale of, making sure the house is ready for sale. So there's a lot of things that the executor has to do. And so you want to choose that person wisely. If you're younger and have minor children, you would also name guardians in your will. You might have trusts for those minor children. Or if you have a disabled child, you might have a trust for a disabled child in that last will and testament. The second here is the beneficiary designations and the transfer on death agreements. So, most people are very familiar with beneficiary designations on your IRAs. When you open an IRA account or a 401k account, you assign a form that's a beneficiary designation that says, when I die, this account goes to the people I've named here. Usually there's a primary and a contingent beneficiary named. If you're married and have kids, it's the spouse primary, generally the children or trust for the children as contingent beneficiaries. You can also have these types of arrangements, beneficiary designations, on your investment accounts, on your bank accounts. Bank accounts, they're called payable on death generally. Investment accounts are called transfer on death. Excuse me, I just went ahead. So those documents would be signed and connected with your investment account, so that when you passed away, these arrangements do avoid probate as well. The one kind of caution here that I want to give to clients is you really don't want everything to be set up this way. If everything is set up this way, there still has to be money left at the end to pay your final debts, your medical bills, your final income taxes. So you don't want everything going to beneficiaries because it becomes their property and they don't have to necessarily consent to pay all those expenses. The other thing we see too, which gets a little more complicated, are irrevocable trusts. So these are trusts that we often see, they might hold life insurance. So when the estate tax limits, which we'll talk about in a little bit, when the estate tax limits were much lower, a lot of individuals would create these types of trusts, which would hold life insurance so that the life insurance wouldn't be included in their estate. And it would instead be part of this trust and could be used to maybe pay any estate taxes when due. The other thing that irrevocable trusts are used for is a lot of estate tax planning. So if somebody wants to make a gift to their children, but they don't want their children to have complete access to it right now, these types of trusts would be established. What is for these types of trusts, you have to give up control. So this is not as common in an everyday planning situation. It's more for those people who want to do some estate tax planning, have significant life insurance, have a disabled child that they might want to plan for while they're alive. So the estate tax structure, the 2024 number is here. It was 13 for federal estate tax purposes. You can either give away during your lifetime or transfer at your death. That figure in 2024 was 13,610,000. This year it's 13,990,000. They couldn't make it 14 for some reason. But for federal purposes, you can share that exclusion. So actually, spouses have almost 28 million that they can either give away while they're alive or at their death. Anything above that amount is taxed at 40%. And I'll talk a little bit later about the changes that are coming up. So also, in addition to the federal estate tax, a lot of states, several states have their separate state estate tax and inheritance tax. I believe that we have a lot of New Jersey residents on the call. So those in New Jersey, there's no estate tax, but there is a separate inheritance tax, which is assessed for individuals kind of out of the direct family unit. Anybody in your direct family unit, kids, stepkids, grandkids, parents, don't pay that inheritance tax, but it is assessed for people outside of that family unit and starts at 11% on anything over 25,000. So if you were to leave assets to individuals that are in that outside of that general family arena, they would pay some inheritance tax, but no estate tax. So as the slide indicates, the federal exclusion amount, there's been a lot of talk in the news about, about some changes with the TCJA, the Trump, the Tax Cuts and Jobs Act that was put through when President Trump was in office the first time. That is set to sunset at the end of this year. It's amazing that 2025 is already here. We've been talking about, these Tax Cuts and Jobs Act provisions sunsetting in 2025, and it seemed a ways off, but it's here. So there has been discussion recently that this is a huge priority of the Trump administration to extend the cuts that are already in place. What that would do is just kind of keep that 13.99 growing by inflation over time. If they were not extended, that federal exemption is going to be cut in half to about 7 million per person. And then there's also some income tax changes that'll come as part of if this doesn't go through. Our general opinion in our group here is that they will be extended, whether that's a permanent extension or whether that's a kick the can down the road a time again, which is generally what they've done historically with a lot of tax changes, especially in the estate tax arena. We don't know. So we're just kind of all waiting as everybody else is to see what they're going to do.